Good morning, everyone. Thank you for joining us this morning. My name is Erin Kopek, and I'm part of the marketing team at Higher Level. And today you've joined our HiNotes program that we do every month. We've been doing this program over the last 10 years to help educate you on topics that are important to us and you as business owners. Today we have Violating with us, and we are going to be covering the new law that protects workers with criminal records. So really looking forward to this information and then of course sharing it with you all. I do want to talk about a few housekeeping things before we get started. You all are in listen only mode. However, we do encourage you to ask questions throughout the presentation as they come up. You have the ability to do that in your GoToWebinar panel. You will see a questions box and you can type in there at any point in time. I will look at those questions and relay those to Phil. And we definitely encourage you to ask questions as they come about. This webinar is expected to last less than an hour, so we won't take up too much of your day. This will be recorded, and we will send out the recorded presentation after the webinar for you to view it later and even share it with your team. Before we get started, I would like to introduce Phil with us and just kind of give you guys an idea of his background and why we decided to bring him on with us today to co-host our webinar. So thanks for joining us, Phil. Phil Violating is an attorney with Sandberg Phoenix Von Goddard and a managing shareholder in charge of its Edwardsville, Illinois office. Phil has practiced law for 22 years and is licensed in the states of Illinois, Missouri, and Arizona. Phil is a regular presenter on a variety of employment law issues and serves on the Illinois Chamber of Commerce Employment Law Committee, advocating on behalf of Illinois employers through the Chamber of Common Sense provisions and legislation under consideration by the state of Illinois. Phil is the co-author of FMLA, ADA, military, and other lead issues, a guide for the Illinois employer, also published through the Illinois Chamber of Commerce. He has been certified as a trainer on Illinois sexual harassment prevention training to assist Illinois employers with their annual training requirements. Phil advises and represents businesses on employment compliance issues and defends a variety of claims and lawsuits filed against them, including alleged civil rights violations. We appreciate everyone joining us this morning, and I turn it over to you, Phil.
Thanks, Erin. Good morning, everyone. Like Erin said, if anybody has questions at any point in time during the presentation, please feel free to use the chat function that is in the app, so we can make sure that those questions get addressed. I know nobody wants to hear me talk consistently for the duration of the program, so please feel free to use that. We want to make sure that if you have concerns that those are getting addressed. So with that said, I am going to get into the program. Turn off my camera here. Hopefully you guys can see the slideshow and we can get started here. So the topic today is the new Illinois law that was adopted. Let's see here. Let's get through here. Senate Bill 1480, known as the Employee Background Fairness Act. Law was adopted by the legislature and signed into law on March 23rd by Governor Pritzker. The law went into effect immediately on March 23rd, so everybody is currently subject to this law. Why was the law adopted? What are the policy reasons behind the Employee Background Fairness Act? So in 2012, the United States Equal Employment Opportunity Commission issued a report that had updated criminal background guidance, and the report was authored to address concerns that African Americans and Hispanics were being arrested at a rate that was 2 to 3 times their proportion to the general population. In this report, the EEOC determined that reliance on criminal background checks was having a disparate impact on African Americans and Hispanics in the workplace. Illinois' response to the EEOC criminal background guidance came in the form of House Bill 5701, which most of you are probably already familiar with. This is the Job Opportunities for Qualified Applicants Act, and it's affectionately known as the Ban the Box legislation. This is the law that prohibits employers or any agent of an employer from considering or inquiring into a job applicant's criminal record or history until that individual has been determined qualified for the position and notified of an impending interview, or if the applicant will not be interviewed until a conditional offer of an employment has been made. This is the one that eliminated the box on applications where an applicant would have to disclose prior arrests at the time. It's important, I think, to address House Bill 5701 in the context of this presentation, because the new law that was adopted that we're talking about here today, that went into effect in March, the Employee Background Fairness Act, doesn't repeal Ban the Box. So Ban the Box is still the law and works in conjunction with the new law as well. So the three previous exceptions to Ban the Box were if the employer was required to exclude applicants with certain criminal convictions from employment under state and federal law. So if the specific job for which they are being hired they couldn't hold because of some state or federal prohibition. Two was if the standard fidelity bond or equivalent was required and a conviction of certain criminal offenses would disqualify the applicant from obtaining such a bond. Or three, if the employer was hiring individuals licensed under the Emergency Medical Services Act. The Ban the Box law does not prevent employers from notifying applicants in writing of specific offenses that would disqualify them from employment based on specific hiring policies of the employer. Again, this provision tracks into the new law, although the provisions of the new law are going to make the development and implementation by the employer of these specific hiring policies a lot more complicated. The penalty provisions for Ban the Box, we believe, are fairly lax. There was written warnings with subsequent fines terminating in a capped fine of $1,500 after multiple offenses. That's significantly different than the penalty provisions that are included under the new statute. What Illinois employers are subject to the new Employee Background Fairness Act? Short answer is everyone. All Illinois employers are subject to the Illinois Human Rights Act, and while the law under Ban the Box, when it was adopted, previously defined an employer to those employers with at least 15 employees, there was a change in 2020 by the state legislature that revised the definition of employee, and now the definition is anybody employing one or more employees is subject to the Illinois Human Rights Act. So unless you are an employer with no employees, which could theoretically be possible depending on how your corporation was structured, everybody is subject to the IHRA now. What's a conviction record? So there are certain parts of the new statute that actually have definitions. This is one of those. So conviction record is defined as information indicating that a person has been convicted of a felony, misdemeanor, or other criminal offense, placed on probation, fined, imprisoned, or paroled pursuant to any law enforcement or military authority. So this could also be through a military tribunal under the Military Justice Code. This definition of conviction record would also include if the defendant has pled guilty to the offense. A lot of times that's not construed as a conviction, but for purposes of this act, a guilty plea is deemed to be a conviction and part of a conviction record. So employment activities that are prohibited under the new law include the use of conviction records to serve as the basis to refuse to hire, segregate, or act with respect to recruitment, hiring, promotion, renewal of employment, selection for training or apprenticeship, discharge, discipline, or tenure, or otherwise related to the terms, privileges, or conditions of employment. So that also is specific language that's included in the new statute. If you would say, hey, Phil, draft a definition of what is prohibited, and we want you to make this, the prohibitions as broad reaching as possible, this is it. So if there's any component of the employment relationship that any kind of an action is taken or a decision is made based upon the use of those conviction records, it's going to be subject to the new law. Now, the new law doesn't completely ban the consideration of the conviction records of applicants or employees, but limits the circumstances under which those conviction records can be considered to one of two exceptions. And these are the only exceptions under the statute that the conviction records can be considered. The first one is where there is a substantial relationship between one or more of the previous criminal offenses and the employment sought or held. That one now is referred to as the substantial relationship exception. Or the second one is where the granting or continuing of the employment involves an unreasonable risk to property or to the safety or welfare of specific individuals of the general public. So for the first exception, what is a substantial relationship? When does a substantial relationship exist? So there are, under the statutes, it's a two-pronged test to determine whether a substantial relationship exists. And first prong is whether the employment position offers the opportunity for the same or a similar offense to occur, and whether the circumstances leading to the conduct for which the person was convicted will recur in the same position. So the first prong, fairly straightforward, and involves comparison of the prior conviction or convictions at issue to the position sought or held by the employee. And the determination needs to be made as to whether there are significant similarities between the facts of the conviction or convictions of the individual and the job duties associated with the position at issue. And again, this could be for an incoming employee. If you're hiring somebody, you would compare the convictions with the job duties of the current position, but based upon the definition in the act, it can also apply to existing employees who are serving in a position who then get convicted of an offense. So again, it's not always incoming employees that you're interviewing. It also applies to employees who currently hold those positions. So the second prong requires a lot more involvement to the analysis, and it's going to be more difficult to determine as the language of this second prong of the substantial relationship test requires employers to predict the future, we believe, because it forces them to make a written determination. We'll get to the requirements of how this information has to be communicated back to the individuals in a little bit, but the employer is required to make a written determination that the prior conduct and that form the basis of those convictions will recur in the new employment position. That's going to be, we believe, extremely difficult to make a determination that any type of conduct is likely to recur. Obviously, we can come up with examples where somebody has a past history of committing a certain offense on a monthly basis for a number of years, and in those extreme hypotheticals, the employer is probably going to have a little bit more flexibility with making a determination that the conduct at issue will recur. But that's not going to be the case for most of the tough calls that an employer is going to have to make with the average employee and the average circumstances that they're going to be faced with. So it's our belief, after reviewing the statute, that due to the inclusion by the legislature of the will recur language in the substantially related exception, that most employers are likely going to be forced to rely on the second exception to the act to use criminal conviction records for employment decisions. So the second exception is what is known as the unreasonable risk exception. Now, I don't know how many of you, what your position is on Illinois politics in the legislature, but in our experience, the legislature at times could do a little bit better job with drafting legislation to include more clear guidance for the masses that are now going to be subject to these new laws. And unfortunately, this law does not include a definition of what an unreasonable risk is under the law. So moving forwards with utilizing this exception, employers are going to have to evaluate based upon the totality of the circumstances what they believe an unreasonable risk is going to be related to specific conviction records of the employee at issue. And it's our position that this is going to involve a risk that no reasonable employer should be expected to bear under the specific circumstances at issue. Again, this is not anything that is going to be objectively measured or quantified as to what an unreasonable risk is going to be. It is going to require a subjective case-by-case analysis of the elements to make a determination as to whether or not an unreasonable risk is present. That's going to put a lot of a burden on the employer to an employer who seeks to use this exception.
Phil, we do have a question that came in.
Sure, go ahead.
Crystal was asking if this meant that Illinois must hire felons if they meet the requirements, or is it still up to the employer?
It's a great question. Felonies are Yes, the short answer is yes. Unless that conviction falls within, or the conviction record falls within one of the two exceptions that the statute now specifies, or if the felony conviction is related to a position that the applicant, individual employee, whatever they may be, seeks to hold, and that felony conviction would, from a statutory standpoint, so either based on a specific provision of Illinois law or federal law, would exclude that person from holding the position at issue, that's always a reason, not to have to hire that individual. But assuming that it doesn't fall into one of those categories, and for you employers who are out there, what convictions, if any, are going to be an absolute prohibition on a hiring decision as it impacts your business. But if that's not the case, then yes, that felony would not preclude an applicant from holding a position unless the employer made a determination that one of these two exceptions applies. So, and the way that they go about doing it is the new statute contains mitigating factors that apply to either exception. So it applies to both the substantially related and the unreasonable risk exception. And these are those 6 statutory mitigating factors. This is kind of the meat of the statute. If an employer is seeking to use those conviction records to take an adverse employment action against, an incoming applicant or an existing employee, these are the factors that they have to look at. There's a gray area in these. So just diving into this, first one is the length of time since the conviction. So if there is a conviction that was last week versus a conviction that pops up on a background check that's 10 years old, and the applicant otherwise has a fairly clean record since the date of the conviction, then the more time that elapses from the date of that conviction, the less weight that conviction is going to have on an employment decision. Second factor is the number of convictions that appear on the conviction record. So if there are, if you run your criminal record background check and, your printer doesn't stop printing for days because the person has a rap sheet that is just completely voluminous, then those individuals, as an employer, you're going to have a little bit more flexibility to use those convictions in taking adverse employment actions. 3, the nature and severity of the conviction and its relationship to the safety and security of others. So this also, going back to the question that was posed, it's our belief that a felony conviction is more serious by definition than a misdemeanor. So if there are felony convictions on the record, those are going to be treated differently than a misdemeanor, albeit for you still have to meet all of the elements and take all of these factors into account in decision making, and whether or not any specific conviction record is going to be used. Fourth factor is the facts or circumstances surrounding the conviction. So, and I think a lot of times this goes hand in hand too with the next factor, which is the age of the employee at the time of the conviction. So if you have a high school kid who catches a shoplifting charge because they grab a pack of Skittles on the way out of the grocery store and plead guilty to that, you know, that's something that you are probably not going to be able to give a lot of weight to when this person is in their mid-30s and is applying for a job. Particularly if, since the time of that conviction in this hypothetical for shoplifting, they've otherwise lived a clean life and don't have any other convictions popping up on their record. So this is going to place some burdens on employers who want to use these exceptions, because, you know, if you get a conviction record, more often than not, you know, you guys have seen these, they show up and it's a very, you know, cursory description of, you know, the court where this happened, the dates, the person's name, the offense, and, you know, maybe some sort of a resulting disposition. But what you're not going to have readily available without doing some additional work is having access to the facts or circumstances surrounding the conviction. That's going to be a lot more difficult to get. It could include a requirement that the actual physical court file be accessed to review, you know, any kind of charging documents and responses from the defendant to really get a handle on what those facts or circumstances were. And obviously that's going to present some difficulties, not only from knowing how to get this, but going and getting those. And the last factor is evidence of rehabilitation efforts. So this is an interesting factor to be included in this analysis. And it's not something, again, that an employer may know automatically when they contemplate taking these adverse employment actions based upon conviction records. Maybe you have this information and maybe you don't. More likely than not, you aren't going to have this. But what this is going to allow is, if somebody has committed what is otherwise a completely heinous crime and was incarcerated and, you know, completely turned their life around and is now a model member of society, at least on paper or from an outward appearance, then it's going to be difficult even to use those more serious and severe offenses as the basis for an adverse employment action. And that's going to come into play from the evidence of the rehabilitation efforts is more likely to come into play in a couple slides here when we get into the interactive process. And unfortunately, this is a brand new statute. Again, March 21, and there is not a lot of guidance, if any, to assist employers in evaluating the parameters of these two exceptions to the statute. And it's unlikely that we are going to receive any clear guidance, even if as it gets piecemealed in, for a number of years. It's always possible that the state could issue some regulations that may flesh out some of the details surrounding application of these exceptions and how to interpret the factors. But the way that we typically receive guidance on these issues is through the Illinois Appellate Courts. So if there is a lawsuit that gets filed, and we'll get to that a little bit later in the presentation, but let's assume that a lawsuit gets filed, then that case goes to, let's say it goes to a verdict. There's a decision that gets entered in the case, a judgment, and one of the parties decides to take an appeal from the state court of the decision that was entered in that case. Then the matter goes up to the appellate court, and the appellate court reviews the decision and makes a determination as to whether or not the trial judge correctly applied the law to the facts and entered a decision, whether it's judge or jury, whatever it may be. We're years away from there being any type of appellate authority through those opinions that the appellate court enters to provide guidance on specific issues related to the statute, in part because it just takes a while for these cases to work their way through the system. But also, one more casualty of COVID is that our court dockets right now were essentially non-functional for these types of claims over 2020. There was no jury trials, no civil jury trials. And so there is a significant backlog right now of cases that are on these judges' dockets that are awaiting progress to bring them to conclusion. And the reason I bring that up is because let's assume that somebody files a lawsuit based upon a human rights violation under this new law. They're going to have to go into queue behind a lot of cases that are already in line for disposition. So it takes a while in general for this stuff to make it to the appellate court, and it's going to take even longer now because this backlog of existing cases is going to need to be cleared before that case even moves forward to the trial court for some sort of a decision. So what are the requirements to implement one of the exceptions? How, as an employer, do you do this? What do you need to do? So there's a requirement in the new law that you're subject to now that requires all employers to engage in what is now referred to as an interactive assessment. And that occurs primarily through the pre-adverse action letter. Final decision is made through a post-adverse action letter. So this interactive assessment is the process that the employer and the employee engages in, and it takes place when if after considering all the mitigating factors, so those 6 factors that we just talked about, the employer makes a preliminary decision that one of the 2 exceptions apply, and the employee's conviction record or records disqualifies them from employment. I apologize for the, hopefully that's not coming up as writing the text here, but so the employer is required to send, let's say after this interactive process has been engaged in, employer is required to send the employee a preliminary decision notice that includes a notice of the convictions that the employer is using to invoke one of the exceptions. So you have to say this is the conviction or convictions that we are relying upon, and you have to forward to the individual an actual copy of the conviction record. So when you get the background check through your vendor who performs these searches for you, you forward to the individual a copy of that conviction record. That's required under the statute. And you now have to include a written explanation of the reasoning for the disqualification, again, taking into account the requirements of one of the two specific exceptions that you're relying on, as well as your analysis of those statutory mitigating factors. So those 6 factors. And lastly, you have to advise the individual that they have at least 5 business days. You as the employer can extend that out, but it has to be a minimum of 5 business days to respond to the preliminary decision notice and provide evidence to refute the accuracy of the conviction record. So let's say that it's a John Smith who's your individual, and they say, yeah, that's great. You know, here's a conviction record for a John Smith, but that's not me. Obviously, under that circumstance, you can't rely on that conviction record. So they'd have to refute the accuracy of the conviction record or provide evidence demonstrating any rehabilitation or mitigation and or otherwise address the employer's concerns. So address the concerns that would be included in the preliminary decision notice. So this is where that last the sixth mitigating factor comes into play. So this is the employee's opportunity to plead their case and talk about all of the life changes and the rehabilitation that they have engaged in since the date of that conviction. You know, if they're now their kids, you know, Boy Scout troop leader, or you know, active in their some sort of social organization or you know, religious entity, whatever it might be, this is their opportunity to do that and to respond to and argue against the application of the specific conviction in this employment related decision. So response to the preliminary decision notice, if there is no response by the employee in 5 business days or such greater time as the employer decides to allow the employee to respond, then the employer can proceed with the adverse employment action specified in the preliminary decision notice. You'd still need to send out the final decision notice. So if there's a response received within the 5 business days, or again, any extension granted by the employer, then you have to take into account what the contents of that response. You need to look at it and review it in the context of those 6 mitigating factors to see if it now changes your position as an employer to the use of that conviction record in an adverse employment action involving this employee. And you know, maybe it does and maybe it doesn't, but at a minimum, the employer is required now to take that response into account, redo the analysis under those 6 mitigating factors, and determine that it either does or doesn't change the analysis, explaining why, and make that evaluation. So as you can see, this is going, if for those employers that want to rely on these conviction records in employment decisions, this is going to be a fairly involved and time-consuming process. So final decision notice. So this is sent to the employee when upon considering the employee's submission, the employer still decides to take an adverse employment action, and it also needs to include, again, the notice of the convictions that the employer deems to be disqualifying, the analysis, again, from the employer justifying the final decision notice, to include the revised analysis of those 6 statutory mitigating factors, taking into account the written submissions received from the employee in response, identification of any procedures the employer has in place to challenge the adverse action. This may or may not apply to you. You are also not required to create procedures if you do not have those existing internally to allow individuals to challenge the adverse action. And then here's the kicker. So there's the notice to the individual of their right to file a charge of discrimination with the Illinois Department of Human Rights. So this is the teeth to this new statute. In the event that an employer does not follow the requirements of this statute to a T, it's a human rights violation under the IHRA, and the employee then has the right to file a civil rights lawsuit to recover damages. So not only will the employee have the ability to pursue a civil rights violation for those employers that don't follow this new law, it also applies to those employers who follow the law and go through the analysis and make their determination that one of these 2 exceptions apply, and walk through the analysis of those 6 mitigating factors, and otherwise makes a good faith attempt to comply with the requirements of this new law, and the IHRA disagrees with you. So the potential exists for you to go through this and do everything that you think you've done the correct way, and the IHRA will say, well, yes, we understand that, but this, you took into account a conviction that's 3 years old, and we think that you only should be able to take that into account if it's 1-year-old. So you just violated this person's civil rights, and they can hire counsel and file a lawsuit against you. It's also unknown at the present time, as an aside, how insurance companies are going to treat this for your businesses. If this is going to be covered under existing EPLI type policies, or as I suspect the case to be, because insurance companies don't make money by paying out claims, I think that you will start to see some policy endorsements and exclusions that come down the road from your carriers that exclude coverage for these types of hiring decisions. So there's a chance that you may have no insurance coverage that would apply to defend these civil rights types of lawsuits. Penalties for violations of the IHRA. So if this employee gets an attorney and they file suit for a civil rights violation, unlike the ban the box penalties, which again, we stated we believe are fairly lax, written warning, progressively increasing $500 fines, civil rights violations are a little bit different animal. So the individual at issue has the ability to seek recovery of uncapped compensatory damages, back pay and front pay, reinstatement to their position if they were wrongfully terminated, or the back pay and front pay would likely apply to those employees who didn't get hired for a job based upon an employer's use of these criminal conviction records. Attorney's fees and costs. This is the real teeth of all civil rights claims in general. In the event that this individual pursues a claim, civil rights claim, and they recover $1 of compensatory damages under the law, they're entitled, the judge can award them their full attorney's fees and costs. These cases often take years to resolve, so you're talking at times 6+ figures worth of legal expenses that individual have incurred through their counsel to pursue a civil rights violation. And then obviously depending upon the severity of the action that was taken by the employer, the court also has the opportunity to impose punitive damages. Just as a reminder, there is nothing in the new law that abrogates the responsibilities of employers in Illinois to continue to comply with the Federal Fair Credit Reporting Act. And there are disclosures that have to be made to the employees when you're running background checks on them, waiver forms that you have to obtain from them as well. So continue to maintain that as your practice. Our office has generated a couple of forms that we have started to use as templates for these preliminary decision and the final decision notices. And right now they're kind of in a shell form. But as we've talked about, and as you probably understand by now from the presentation, again, there's a lot of subjective analysis that needs to take place for you to utilize one of these two exceptions. And when generating these preliminary, in particular, the preliminary decision notice. And Illinois has a habit of drafting legislation like this where the employer, business, whoever it might be, has to generate the kind of the evidence to get yourself in trouble. So if you intend to rely on one of these two exceptions, I would strongly encourage you to really take the time to follow the statute, ask questions if you need to, seek legal advice as appropriate, to prepare a thorough preliminary decision notice. And the reason being is you're going to be bound by whatever you put in that preliminary decision notice and then also in the final decision notice. So if and when this aggrieved employee decides that they're going to hire counsel and file a lawsuit for a civil rights violation, you're going to be stuck with what you put in that preliminary decision notice and your final decision notice. If you tell an employee that we are relying on a specific conviction and you do your analysis and send that off through your preliminary decision notice and your final notice, you're not going to be able after the fact when this matter goes to trial to say, oh yes, well, we relied on this conviction, but we also relied on all of these other things. That's not going to fly. You're going to be stuck with what you put in that preliminary decision notice and your final decision notice. So the contents of those, if you intend to use one of these exceptions, are going to be very vital to your ability down the road to justify the decisions that you made. Questions? This is pretty much the end of the presentation. So this is my email and phone number. If anybody has questions and you want to email me after the presentation or give me a call, or if you have something that comes up, don't hesitate to let us know. We have a fairly large team of attorneys who work in our employment and labor law practice group within the firm across multiple states, and we can hopefully walk you through some answers to these questions. So that's it. Thank you for your time. I don't know if anybody has questions, Aaron. I don't know if anything else has come in that.
Yes, there is another question asking about if this new law will eliminate the at-will employment contracts.
So this law does not do that. There is, and I don't know who asked the question or if they're talking specifically about the this specific new law, the Employee Background Fairness Act. So Senate Bill 1480 does not do that. Now, as an aside, there is a bill pending in the Illinois legislature that's under consideration where they are seeking to do just that. I know this is getting off topic a little bit for our presentation, but that law has not been passed yet by the legislature or signed by the governor, but it's something that we are actively monitoring and are continuing to work through the Illinois Chamber of Commerce to provide input from businesses in the state with positions, in essence, in opposition to that law.
And then we did have a couple people asking about the recording, and we will be emailing that out later today. You'll receive that in your inbox with the email address that you registered for. So that absolutely will be sent out. And I do not see any other questions, Phil. So.
Well, perfect. Well, thank you again, everybody, for your time. Hopefully we haven't scared you too much, but I do, to the extent that you want to use these conviction records, do take the time, walk through the statute the right way, and have good outgoing product to protect your businesses. So.
All right. Thank you so much, Bill, for doing this for us today. And thank you, everyone, for taking time out of your morning to attend. We have another great topic coming up on June 30th that will be discussing personnel documentation with one of our other employment law attorneys. So please, if you would like to register for that or want advance notice, you can email me at hello@hirelevel.com, and I'll make sure that you have that in your inbox. Everybody have a great rest of your day, and thank you again.